joint City Council and Planning and Zoning Commission workforce session for Monday, July 13th. So I'm going to call us to order, and I'm going to allow the P&Z to call to order also.
Yes, P&Z will call to order. Thank you.
Thank you. Our first item of business this afternoon are public comments. We do have one person signed up to speak, so when I call your name, I guess you can sit up here next to me. Oh, podium, okay. And please state your name and address. You'll have 3 minutes to address at this time. So first, our speaker that is signed up is David Coe.
David Koch, 3243 Brincrest Drive. Sounds like it. Okay. David Koch, 3243 Brincrest Drive. I have a simple request. Oh, there we go. As a representative of my family and speaking on behalf of the citizens in our neighborhood, my request to both the City Council and P&Z, or whichever board needs to make the decision, is that we have a better representation or a fairer seat at the table at the P&Z meeting coming up on the 27th, and if there's a subsequent meeting with City Council on this. I don't believe that the 3-minute limitation allows the citizens in that neighborhood adequate time to present the issues that we have. So I'd ask that you, whether it's informally or formally, if it needs to be formally, you got a council meeting between now and then, that you could establish a rule that gives us an opportunity to have equal time or at least 30 minutes to present our position, with some of the speakers having more than 3 minutes. So it's a simple request that we give a bigger seat or get a better seat at the table to present our issues. Okay.
Thank you. That is all that I have signed up to speak comments this afternoon. So do that now. Let me just ask, anybody else has any comments? Because we are going to go into executive session real quick. Okay. All right. So with that, let me just read us into executive session. The Planning and Zoning Commission and City Council will convene in closed executive session, pursuant to Texas Government Code Section 551.071, consultation with attorney to discuss, consult with, and receive legal advice from the city attorney regarding Farmers Ranch Project 2025.014, property located at 12150 Medical Parkway.
All right, so with that in mind, I'm not quite sure how to structure the executive session, so that it's just. So people with the.
Yes. She needs to read P&Z into.
Great, thank you. So the Planning Zoning Commission and City Council will convene into closed executive session pursuant to Texas Government Code Section 551.071 in consultation with attorney to discuss, consult with, and receive legal advice from the city attorney regarding the Farmers Ranch Project 2025.014, the property located at 12150 Medical Parkway. Thank you, Conrad.
Okay, so we're going to go down to the other room real quick. Audience, I don't think Thank you. We are back and ready to move on to item D1, which is conduct a joint discussion regarding property located at 12150 Medical Parkway and provide feedback.
Just confirming on the P and Z side that we will hear a joint discussion regarding a property located at 12150 Medical Parkway and provide feedback. Council, commissioners, discussion?
Who's leading this? Go ahead, Council.
Is this working? No, I was just gonna,
I'm sorry. Let me just recognize that Councilwoman Villafranca is with us remote, since I didn't do that earlier. Thank you.
I was just gonna mention to the public and those who may be watching that there is going to be a planned town hall to discuss this issue more publicly with the residents. I don't know if a date has actually been chosen, but we're hoping to have that occur prior to the P and Z meeting of the 27th, I think it is. So I just wanted to add that for those that might have an interest in attending that town hall for more discussions and questions.
I guess I'll ask if council has any thoughts or comments that they'd like to share at this time in regards to this particular project. Seeing none. Oh, awesome.
I would just like to encourage the residents to come to the town hall to get all the information directly from P&Z and from the developer. That way you are informed and know exactly what's happening straight from the developer.
Yeah, I would just also add to that, that there's seems to be a lot of misinformation going around on social media, so I think it's very important to come and get the facts instead of reading or listening to all the things you hear online.
And I would still like to hear feedback after the town hall to see what you think after you've heard that information. And then remember, if you email all of us, we may not respond because of quorum.
Councilman Villafranca, any comment?
I'd just like to really remind everybody that it is important to make sure that we are actually getting the facts and not, what people think might be happening. And I would encourage the city manager's office to create maybe a fact sheet. We already know what the majority of misinformation is, and I think that that would really, really help in alleviating a lot of the misinformation that's out there.
Thank you. And again, the town hall, not to worry, we are working with the developer to try to find an acceptable date. Once we do, we'll try to give ample notice to residents via standard notification channels to make sure that especially the area immediately surrounding property in question is notified.
And commissioners, any thoughts, considerations, things to add? I'll just say thank you for all that came to the previous meeting, and I appreciate always having citizens present at our discussions, and you can come to other meetings too. And we always appreciate it.
I would also like to add my appreciation to planning and zoning for tabling the issue, as it's important to have all the information needed to come up with a proper decision. It's my belief they didn't have the proper information to make an appropriate decision, so I just want to commend them for tabling it for more discussion, and we'll continue to have more communications about it. Thank you all.
Any more comments on D1? Seeing none, we will move on to item D2, which is receive the presentation of the city attorney, from the city attorney regarding the roles and responsibilities of the Planning and Zoning Commission.
Well, unless y'all have any objections, rather than sitting with their body and having to stand up, really kind of just sit here.
towards a conversation, then I'd like to thank the Academy. And it's not even plugged in, and it's still working. It's a miracle of modern science. So I think first and foremost, it looks like Chris Metcalf, who typically attends your P and Z meetings, is not going to be here tonight. And since I'm already here, because I'm already here, I might just be sitting in on your meeting, which is fine, you know. I don't know how to use it. It has two buttons, and I can't use two buttons, I swear. Y'all know that that we have, or if you don't know now, you will be informed soon that we're going to have a joint council or joint board and commission training session later this month. All of you are supposed to be there and go over all the same stuff that I don't want to go over tonight, but probably will briefly. And I do want this to be more of a conversation, and I want to make sure this is the presentation I'm going to be showing or using during the joint meeting later this month. But for our purposes for tonight, there's just one or two slides that we'll talk about this evening. First and foremost, P&Zs in home rule cities are required by law, Texas Local Government Code. It is comprised of, I believe, 7 with 2 alternates. And I say that because we've got some ordinances on the books and off the books that aren't really, in my mind, clear cut. How many of y'all are regular members? Raise your hand. And just one alternate. Is there a vacant alternate seat, or the alternate just didn't show up tonight? I'm looking at the
I
chair.
believe we have some change in the status of the commissioners, so one person rolling off, as I understand it, from staff informing me just prior to this meeting.
Okay.
So that represents one absence, and another alternate indicated they wouldn't be able to make it to the joint session, but will be in attendance in our regular meeting, if I understand correctly.
Okay, so we have officially 5 members and 2 alternates? As we sit here right now, before actually anybody is actually removed and replaced.
We do generally have 7 and 2 alternates.
Or 7 and 2, I'm sorry, 7 and 2 alternates, okay. Now, I saw an ordinance that said we have 9 and 3 alternates and 3-year terms of office, and I don't know if that was ever adopted or not. I also saw 3 different versions of our subdivision regulations, none of which, by the way, are in our code of ordinances, which is something that I talked with staff about a couple of years ago, but I don't know what the resolution was. But in any event, y'all understand how the alternate system works. An alternate may attend or should attend all meetings. Do y'all let alternates preside at the dais when they're present and not actually serving in place of a regular member?
So for our purposes, alternates do participate in discussions and they are non-voting. Again, unless, of course, we have a regular member absence, in which case an alternate would step in to that voting position. But generally, they are present. Sometimes just because of the number of seats, they may be on the secondary row. But
Right.
we do generally have all of those members present, again, as their schedule allows, and then,
It's perfect.
represent attendance.
Yeah, no, that's perfect. In some series, the P&Z alternates and BOA alternates just simply sit in the audience and watch. It's pretty boring for them after a while. So having them participate, there's nothing wrong with it, but their votes, they don't get to vote. So y'all are doing it exactly correctly. If you have multiple alternates present and only one vacancy in a regular member's position during a given meeting, how do you pick the alternate who gets to serve?
Those alternates are designated as alternate 1 and alternate 2, and they know their designation.
Okay. And so alternate 1 is the one who always gets to preside and play?
Correct.
Okay. All right. You guys get to determine your own rules of procedure. You can do it any way you want, and you are doing it so far, as best I can tell, pretty much ideally. I mean, I couldn't recommend or ask for something better. You're doing it just fine. What is a quorum of P&Z?
Quorum is 5.
Okay. And it's a trick question. You got a P&Z comprised of 7 members, right? A quorum is a simple majority. 4 out of 7 is a majority. And it doesn't matter if it's any combination of alternates or regular members, so long as you have 4 people present. you have a quorum. If the commission consists of 7 members, their quorum is a majority, which is 4. You can continue and to do business, you can conduct business when you have a bare quorum. Anybody that leaves the room, the meeting recesses or adjourns, depending on whether you know they're coming back or not. You wait, if you don't have 4 members present, how long do you wait before you decide that you should cancel the meeting?
We usually defer to staff because they usually know actually ahead of time. I don't think we've had an issue where we've just had somebody not show. Our members are very good about informing us ahead of time, if that happens. So I don't think that we've ever had that issue arise, thankfully. We have very good attendance and
Yeah.
folks are generally very prompt. So,
Have you-
I would defer to staff and having them check our regulations of that required time, but again, this has never come to pass.
Okay, have you ever had a meeting that you, so then therefore you've never canceled the meeting because of a lack of a quorum?
Not to my knowledge, at least in my time here, but we have canceled meetings because there's nothing on the docket.
I know. I know. That's wonderful, actually. I've had some P&Zs, one in particular, where I attended all their meetings, and their meetings would last until 11, 12 o'clock at night. 2 meetings a month for that long. It was incredibly painful. So you adopt your own rules of procedure. You figure out how you guys want to do it. And the chair is the one who is primarily responsible for determining and enforcing those rules of procedure. So far what I'm hearing is you guys are pretty much exactly on point. All P&Zs have 2 primary functions. Number 1 deals with zoning. Number 2 deals with subdivisions for zoning. As I mentioned in executive session, I can only say this part of it that we talked about in an executive session. You make recommendations to the council based on what you believe to be in the best interests of the public health, safety, morals, and general welfare of the city. It's a very vague standard, but what you believe is best for the community is what you need to be relying on. That's your goal, is to figure out what you believe is best and then make that recommendation. Zoning is discretionary, not ministerial, which means that because it's kind of a vague and a nebulous standard, whatever you decide to do, whatever you as a group agree on, it's pretty much whatever you think. Same thing with the council, whatever within their discretion they think is best. Zoning regulations are, to contest the zoning regulation, it's a relatively high standard. In fact, it's a really high standard, although most judges don't ever follow it. They just think lawyers are being lawyers when they say that it's a tough burden to overcome the validity of the zoning regulation. But in theory, there is a high standard. Distinct from plotting, which is purely ministerial, you can do what you think is best when you make a recommendation for a zoning change or a zoning regulation. There are 2 categories, the regulations and the zoning changes. Statutes don't really draw a distinction between, statutes do draw a distinction, but there are some recent cases that seem to ignore them. A zoning regulation are things like setback regulations or use restrictions in different areas of town. A zoning district boundary change or a zoning classification change, what I regard as being changing property from, for example, single family to commercial. But there is, as I'm sure you know, a whole lot of gray area in between those bright line distinctions. A plat application, on the other hand, is completely different. If a plat application meets all of our requirements in terms of our regulations, zoning, code, and everything else, if the application meets our requirements, your recommendation, your approval is ministerial. Thou shalt approve a plat that meets all of our requirements. If you do not, then the individual members who voted against approval could be sued only in their official capacity. The city will cover you, but your name will appear in the pleadings. And the law is clear, you have to approve a plat application if it meets our requirements. When was the last time you all ever considered a plat application, whether preliminary, final, replat, amending plat?
Yeah, I think we had a plat just last month maybe, and we went over these ministerial items at that juncture. Yeah,
Did
we're
Chris
very
go-
clear.
Did Chris go over that with you?
No, we're well aware, we've seen plats before, and we just had staff remind us.
Okay.
Just as a point of reminder, but I think everyone on the dais actually already knew what I asked staff to remind them. It was more for privilege of those watching online.
Yeah, okay, thank you. Yeah, wow. Gosh, you're making my job easy. What are our subdivision regulations? I looked at what's called Ordinance 1430 that was adopted back in the 2010s. I also have in my system a set of regulations that were adopted, I think, in 2023, and then some revised version that may have been adopted in 2024, but I don't know if they were ever adopted or not.
Yeah, you're bringing up an excellent question, because in fact, we just heard a brilliant presentation from staff about cleaning up our CZO because we're aware of some of these discrepancies. And so they're undertaking a comprehensive review to ensure that we are on track with all of those things. So
Up to date.
it's a very timely thing that you bring up, and we're aware that we need some amendments and work on our CZO, and they are hard at work at that.
Well, not talking about zoning per se, but subdivision regulations, separate and apart from our comprehensive zoning ordinance. Subdivision regulations are, a lot of cities have unified development codes where the two distinct sets of regulations are blended together in one unified code. We still maintain a distinction between subdivision versus zoning, and many cities still do. But, you know, the subdivision regulations will contain things like all of the planning requirements, all the criteria, standards for approval, things dealing with the actual subdivision of attractive real estate. Zoning is the uses and the regulations associated with the uses put on property. I'm not quite sure. I'm going to get with staff one of these days to figure out exactly what the status is of our subdivision regulations. We don't really have too many issues. I don't believe, we're landlocked. We don't have any ETJ. We don't have large tracts of vacant land, although we do have some out there that could still be platted or subdivided. So to hear that we had one last month is encouraging. There is work out there to do. But I would tend to think that more mature cities tend to have less subdivision regulatory activity because there just isn't lots of vacant land that developers are seizing up and building on.
Precisely. Farmers Ranch is 12 square miles are largely built out.
But the size isn't critical. I've got cities a lot smaller that are, oh my gosh, plats every day. So, but that's good. I'm glad to hear that. All right, so let's talk about Robert's Rules of Order briefly. This I go over with whenever I do board and commission and council training. And I want to really kind of be brief about this. The chair does run the meeting. Remember, it's your responsibility to ensure the protocol and dignity of the conduct of the meeting. You call people down when they're being aggressive or abusive or disruptive. If you have somebody in the audience yelling and screaming, if you have a large group of people that are clapping and cheering, it's up to you how far you want to let them go. Right? I mean, I got a bunch of cities where the mayor will say, not in this one in particular, but you'll have a large group in the audience and somebody will say something when they're speaking at the podium during citizens' input, and then everybody starts clapping. The mayor says, don't be doing that. We need to get through the meeting quickly, so please don't clap. And then after the next speaker sits down, everybody claps again. They just ignore the mayor completely. So that's your call on how you handle it. You set a rule of thumb is anybody and everybody that wants to attend has the right to attend and to speak. If you have citizens input at the beginning of your agenda, they get to speak then on anything they want, whether it's on or off the agenda. If you have a public hearing, then they also have a chance to speak during the public hearing. And you can ask them, would you rather withhold what you have to say now and wait until the public hearing, because they'll give you a chance to speak then, or do you want to talk about it now? Question is, can you exclude them from speaking during the public hearing if they spoke about it during citizens' input? And the answer is yes. Yes, you can, because you get 3 minutes. Right? I have one city and only one that regulates it down to 2 minutes. I'm not comfortable with that. 3 minutes is ideal. You can impose whatever reasonable regulations you think are appropriate for the circumstances. Limit them to 3 minutes if you want. Let them go over every once in a while. That's what I would do. You don't have to if you don't want to. Some cities, they cut the mic off at exactly 3 minutes. And some of them have like a buzzer that's really loud that goes off at exactly the 3 minute mark. But however you want to do that. if someone in the audience is being disruptive and you're not noticing, and one of you guys are, what are you guys supposed to do? Exactly.
Is that true at council meetings also?
It's true for council meetings as well. Somebody in the audience is being disruptive, and not necessarily because of noise, because everybody, the chair would certainly know that. They may be on the side of the room doing something that the chair doesn't see, but it's directed at you kind of thing. If it's disruptive, you call a point of order. Madam Chair, this individual in the audience is being unduly disruptive. Would you please provide an admonishment? The chair's job is to provide an admonishment saying, please cease the disruptive activity. If it continues, call a point of order again. Second admonishment is, I'm admonishing you a second time to stop the disruptive activity. If it occurs a third time, then I will need to be asking you to leave the meeting. When it happens the third time, you say, I'm sorry, I've given you 2 prior admonishments, 3 strikes, you're out. You must leave the meeting now. You can stand out in the lobby all day long if you want, but you have to leave the room at this point in time. If they refuse, what do you do?
Thankfully, we have typically our law enforcement in attendance, and I think just their presence usually encourages individuals to adhere to those. So again, I don't believe I've ever had to give more than a single admonishment. I have done that, but just in a general sense of, making sure that we follow order and decorum. But generally, I feel like thankfully our residents know that they're there to be heard, and I hope that they feel heard, and in doing so, don't feel the need to be disruptive in that process. So
Okay,
this
good.
has not been an issue, and we're thankful for our officers in attendance, and that sets, I think, a standard where folks understand that they're at a serious public meeting.
That's good. If law enforcement is not present, you've given them the second admonishment, you've then given them an order to leave. If they don't leave at that point in time, they
David?
get your cell phone, call 911.
David, is there any leeway for the chair to consider more than 3 minutes?
Yes.
So the
Absolutely.
chair can have leeway if she or he feels they want to allow that person to speak for more than 3 minutes, they would be allowed to do that?
Absolutely, the chair can allow that. It's discretionary. It's not a rule that's etched in stone, it's a rule of thumb. You keep it to 3 minutes because if you've got a whole bunch of people here and you give everybody 5 to 10 minutes, it's going to take all night. If you allow one speaker 5 minutes to speak, if you say 3 minutes is the limit, the first speaker gets up and speaks for 5 minutes. The second speaker is going to say, they got 5 minutes, I want 5 minutes too. Right? Now, if you say, because we only have a handful of people that want to talk on this subject, I think it would be appropriate to allow each speaker up to 5 minutes. You can do that if you want to. Other commissioners can call a point of order and say, I disagree. I think that 3 minutes is enough. I mean, I'm sorry, but the Gettysburg Address, the most famous speech in American history, was 272 words long. It took less than 3 minutes for Abraham Lincoln to deliver the speech. So 3 minutes is not unreasonable. If you want to allow more, you can. If there are people in the audience wanting to ask questions of you while they're sitting in the audience, either during citizens' input, and they're not the one at the podium, during a public hearing, and they're not the one at the podium, or during your deliberations. I have some smaller towns that will allow people in the audience to ask questions after citizens' input of the public hearing items have been closed. And they respond occasionally. To me, it just makes me really, really nervous because it can go downhill really, really fast. In larger, more formal settings, you would never allow somebody in the audience to raise their hand. I got a question. The answer is, I'm sorry, we will not recognize your question. Right? That's the formal, correct process. You're not bound to it, but exercise discretion. But I would recommend against allowing that kind of thing to happen. If a commissioner has a question of somebody in the audience, after or even during citizens' input or public hearing, I would also be kind of concerned about that. Now, when you have a staff presentation or you have the applicant do a presentation, I don't know how I could handle making a correct decision without asking any questions at all. And so ideally, after the public hearing, while the applicant is presenting their case, and you should be allowing them more than 3 minutes because it's their nickel, you would go down the line and ask each commissioner if they have any questions, yeah? And staff would present they would do their presentation, go down the line, ask if each member of the commission has a question as well. If you all have any questions, no questions. If you all have questions, then please keep them short and sweet, but feel free to ask them. That makes sense? It is a very strong rule of thumb that you do not allow speakers during citizens' input or during the public hearing to ask questions, or that you should feel compelled to respond to questions. It's much more significant during citizens' input than it is during a public hearing. Public hearing can be a little bit more of a free-for-all, if you will. Citizens' input should be closely, in my opinion, should be closely regulated. Everybody gets 3 minutes. When you're done, sit down. Thank you very much. Don't ask them questions and don't answer questions. Under the Open Meetings Act, if it's something that is not on the posted agenda, and they begin asking you questions about it, when one of you answers, well, there's an exception in the act that allows for that. But when another commissioner has some input on it, that's not just answering a question of fact or policy, that becomes a deliberation. And because the exception is so slippery, it's generally a good idea, a best practice to, during citizens' input, don't ask questions, don't answer questions, nod, let them criticize their government, regulate personal attacks, but when their 3 minutes are up, grin and bear it, and ask them to sit down and be polite about it. That makes sense? Always follow the agenda. You can follow the items on the agenda in the order in which presented, but the chair has discretion to shuffle the agenda items, subject to points of order by other members of the commission. Chair says, look, we've got item number 7, that's only going to take a couple of minutes. Item number 5 is going to take a lot longer. I'm going to move agenda item number 7 up to agenda item number 5. You have the authority to do that without asking for permission. You all may have an objection. If you do, you call a point of order. Process, whatever you object to, a procedural matter that the chair is ruling on, that the chair is doing. It's like making an objection in court. Key your mic, Madam Chair, I've got a point of order. You state what your point of order is. The chair may agree with you, and if she complies, then your objection has been met. If the chair refuses, then you either accept her refusal, or you say, Madam Chair, I'd like to make a motion that we do not move agenda 7 or agenda number 7 to agenda number 5. And the chair then has an obligation to look for a second for that motion. If there is no second, the motion dies for lack of second, and the items have been moved. If there is a second, then the chair calls for a vote without discussion. If the majority vote is in favor of the point of order, then agenda 5 is agenda number 5, agenda 7 is agenda 7. The chair has been overruled by a majority of the commission. I understand how that works. Okay. I would guess that has never happened. It's extremely unusual for that to ever happen, especially with chairs that have the ability and the experience to do it properly. You will never approve an item in the negative. Make sure that you understand what that means. Madam Chair, I move that this application be denied. I second that motion. All in favor say aye, and only 2 people say aye. The motion to deny has failed, but the item has not been approved. You all understand that? The item has not been approved. You must have an affirmative motion and vote to approve just about anything. If you do not approve an item, then it either A, dies for lack of a second, you move on to the next agenda item, or you consider tabling it or doing something. But you should, ideally, there will be a motion to approve that will pass, and the recommendation's been approved, or there will be a motion to recommend a denial, and that will pass as well. But there's nothing in between. You'll get that. And it gets really confusing if you're talking about a motion. I move to recommend a denial, and you only get a second.
And thank you for adding in recommend, because before you were saying approve and deny, but just a reminder that we're a recommending body. So thank you for correcting.
Yeah, that's just a shorthand. That's just a shorthand. Y'all are only, all of your motions should be, I move that we recommend approval, or that we recommend denial,
Other than those plats.
other than plats. And I got to tell you, I struggled with locating the provision in our subdivision regulations that indicate that the P and Z has final plat approval authority, because there has to be an ordinance that says so. 2013 regs were the older ones that I looked at, ordinance 1420. P and Z simply recommended approval, and then later iterations suggested, and I couldn't tell if they were passed or not.
But isn't that also, there was a change in the state legislature, and that was part of that as well. So now some plants are also approved administratively based off the change in the state legislature.
We could do administrative approvals. We can also do conditional approvals. The conditional approval, I have always for decades recommended always recommended against any kind of a conditional approval. The legislature, apparently I wasn't the only one doing that, so the legislature amended the statute in a couple of different sequential sessions. And you can't do conditional approvals. You need to be really, really careful about that, though. I got to tell you that apart from the administrative prerogatives that the statute requires, the tasks that it imposes on staff, the reason why conditional approval should be disfavored is because, real simple, if it's a final plat, you say, well, I recommend, or I move that we approve this final plat with these 3 conditions, right? That's seconded, the majority votes in favor of. The plat's going to be signed by the chair and by staff and then recorded. And those conditions aren't going to appear on the plat itself. If the applicant, the developer, the property owner never complies with those conditions, they become completely unenforceable. You all understand? So for a conditional approval, what I would suggest is, I'd like to approve this conditionally with the following conditions, and you can read them off into the record. But if it's a plat application, you got to rule on it within 30 days of the day that it was filed with the city. You can't extend that 30-day period. If it goes beyond 30 days, you've approved it whether you like it or not by operation of law. So if you have time, if the developer signs a statement that agrees to extend the 30-day plat approval deadline, and it's in writing and signed, and you got it in front of you, you can say, well, I'd like to approve this with the following conditions. My suggestion would be, don't approve it with those conditions. Deny it, and then say, without prejudice, if conditions are satisfied at the next time this comes up, then I would be inclined to approve it. If you do a conditional approval, it should really only be limited to a preliminary plat and never a final plat. Although statutes don't say that you have to. You can do it otherwise, but understand the effect, the position that you put staff in when those conditions are not met. Tabling is a misnomer. When you move to table something, that means to take it off of immediate consideration, and then you place it on the table so that it can be brought back later on during the same meeting where some other subsidiary issue is first addressed. The vernacular, which is common in virtually all cities, is when you move to table an item, that means you're not approving, you're not denying, you're just simply removing it from the agenda so that it can come back later on a future agenda. We all understand that. So that when you move to table, regardless of what Robert's Rules of Order says, what you mean is, I want this taken off of tonight's agenda so they can come back at a later agenda. If you move to table something indefinitely, instead of moving to deny, because some people think that that means the same thing as denying it. If it's tabled indefinitely, you'll never come back. When you move to table something indefinitely, expect to see it again on the very next agenda. There's no such thing as tabling indefinitely. You table it or you don't table it. If you table it, it's going to be coming back, it should be coming back on a future agenda, maybe the next one or one down the road. You all get that. Okay. And if you repeatedly table an item, the council may regard that repeated tabling as being effectively the same thing as a final report recommending denial of the recommendation of the P&Z, denial of the zoning application. And so with that in mind, you understand what the explanation of the vote is. I think we talked about that briefly before. You have no obligation to explain the reasons why you're voting. You have no obligation to explain the reason why you vote in favor of or against any motion. Sometimes you may feel compelled to do that. And for the benefit of the public who may be sitting in the room watching, it doesn't hurt to do that, except if you have a group of angry citizens, aggressive people that are out there that really think that you're doing the wrong thing for them and for the city, the more you explain it while you're on the dais, the more likely it is that you're going to get trapped into a long and protracted discussion either during the meeting or out in the parking lot with those citizens. You have no obligation under the law to say anything about why you vote yes or why you vote no. You just have to vote yea or nay, and that's it. Sometimes it's a good idea to at least let the people in the audience understand why you're voting in a certain way. That makes sense. If you do feel compelled to explain it, please be short and sweet. Understand that the reason why you vote in favor of or against any item may not necessarily be the same reason why somebody else on the commission voted in favor of or against. We'll get that, right? I mean, you may think that it's a good idea because, I don't know, I mean, you like more traffic. Somebody else may think it's a good idea because, you know, they like very large development projects with lots and lots of people. I mean, your reasons may be different. So when you explain the reason why you're voting in favor of or voting against, that isn't necessarily shared with everybody else on the commission. You're solely speaking on your own behalf. You got to be careful when you do that. Please keep it short and sweet. If you need an escort to your car in the parking lot after the meeting, we should have law enforcement present, just in case. You need to be, in all circumstances, objective, and what that means is, and I can't emphasize this enough, the decisions that you make must be based on what you believe to be in the best interests of the health, safety, morals, and general welfare of the city. Not a handful of people that are in the room. With all due respect to those that are in the room who feel strongly about something, you can't ignore them. They are your citizens. So are the tens of thousands of people who are not present, who are not here speaking about it, who may have a casual interest or a strong interest in the outcome, but just couldn't make it to the meeting. Your decisions have to be based on what you believe is best for the city as a whole, not just the handful of people that live nearby. Although, without ignoring the fact that the people that live nearby are going to be impacted the most. So you can't ignore them. By all means, please don't. And understand that, you know, there are a lot of people in a lot of meetings, and not necessarily here in Farmers Branch, but what I've seen in other cities, some people that are just, I mean, it's really difficult that they get up there and they criticize, and they say nasty things about individuals. And I have to emphasize to the mayors in those other cities that, you know, those people are our citizens. We are here for their benefit. We serve all of them. This is, in fact, public service. You guys get paid tons and tons of money for doing this, right? See, nobody gets that. Nobody gets that. You are here for reasons that are not personal to you. I'm going to guess that each of you agreed to serve on the Planning and Zoning Commission and to do this work, not because you're gaining some kind of personal benefit out of it, but because you really want to do something for your community. And your community means all 45 plus or minus thousand people that live here in Farmers Branch. So you need to keep that in mind while you preside. You got to be nice to everybody. I shouldn't say nice. Statesmanlike and diplomatic. You know, we are all public officials, and we have an obligation to represent the city in all things, not just while we're on the dais, but while we're at the gas station, we're shopping at the grocery store, we're driving down the street and someone cuts us off. You don't want to get in front of them and brake check them. You don't want to stick your hand out the window and give them a sign. It's because you are a public official. So maintain objectivity, maintain proper protocol and dignity, and understand that you're doing this for the betterment of the community, not for yourself. We'll go over some of this stuff again at the end of the month during the joint board and commission training session. We'll go over other things as well later on. From your perspective, it's really simple. You'll make recommendations to council to approve or deny, and roll on class. Questions?
So I have a question regarding the public hearing part. Many times, we hear a presentation, we say, this is a public hearing, I don't have anybody signed up to speak. Well, sometimes people don't know whether they want to speak or not until they've heard the presentation. So is it allowable, I think I know the answer, that somebody raise their hand, they want to speak, they had not previously signed up to speak, I am going to let them speak. Yes?
Absolutely nothing wrong with doing that. Nothing wrong with doing that. By allowing people to speak, that's the, if you're concerned about litigation or the validity of an ordinance that might subsequently get questioned, there is nothing wrong with more speaking than less speaking. In all circumstances, err on the side of caution. A lot of people, I mean, you can, and I kind of like the concept of relegating public hearings to the very beginning before you do the applicant's presentation. I like that concept. If somebody else wants to speak again, you have the discretion to allow them to speak again, subject to a point of order called by a member of the commission. If you do that, you know, that means that anybody else who spoke already is going to say, you let them talk, you know, I want a second chance at it. I mean, you understand how it can devolve into a free-for-all. Once you follow a course, you need to be consistent. So you take a chance when you do that, but okay, I mean, but it's not really a dialogue. I mean, you all understand, it's not really a dialogue between the applicant and the citizens that are signing up to speak. I mean, it's, y'all are the ones who make the decision. And so you need to hear what the citizens want to say. You need to hear what the applicant wants to say. You don't need rebuttal and surrebuttal. It's not a discussion. It should be pretty much a one-way deliberation. But you can if you want, just be careful with the question. Okay. So, thank you.
All right, any other questions? Okay. Then we will move on to item B3, which is discuss vision, priorities, and collaboration between the Planning and Zoning Commission and City Council. So I would just like to say, I do have a priority, and that is I'd like to focus more on training. And to that point, as I mentioned last week, I'd like to invite in industry experts to come in and make presentations about what is happening, not only in our city, but the Metroplex in general, and benefit from their expertise. We've had a lot of discussion about multifamily, and so when we do have, for example, the Apartment Association of Greater Dallas, I'd like to have P&Z come in and listen to this presentation because it pertains to what both of us do. Perhaps same for the Metrotex Realtors and then any other organizations. Conversely, if you all are having training, I know we've got some, I can't remember the initials of it coming up.
Yes, the Texas Midwest section of the American Planning Association, APA, does have an elected and appointed officials training, and I believe you would have already received that information. I believe, Mayor, I remember you attended in the past, as did I, and I know a number of members of our commission have attended that, and it's generally held, I believe, is it North Richland Hills?
Yeah.
And a very excellent full-day training, takes us through all the plats and all the things. So I think that's why our commission was so well knowledgeable on those issues.
Yeah, I just think that sort of stuff is great, and whatever we do to increase our knowledge base, because the decisions that we make are, they're really important decisions for the community, and if we have more education, more basis to operate from, that just benefits everybody. So that is one of my priorities moving forward. So, Council, any questions or any comments or?
I think mine would be more towards Ben. I think I would like to learn more about how P&Z works, because earlier I found out that you guys have a process where you discuss, comes to council, and then it goes back to you. So I kind of just want to see how that process works, just for my knowledge to be informed.
Anybody else? Anybody else? Councilman Villafranco?
And commissioners, any notes on better collaboration or coordination between city council and our P and Z?
My only comment is, I think P and Z is somewhat at a disadvantage compared to city council when we evaluate issues. When we go to the P and Z meeting, we get the docket 4 days before, no input from anybody. All we have is a handful of documents from staff to review. And then in that one meeting, we have to make a decision. So we're operating on quite limited and time-constrained information with which to make a decision. By the time, then 2 or 3 weeks later, it goes to the city council. You've had the benefit of seeing the comments that were made at the meeting, you saw the questions we asked, you got to talk to other people during that interim period. So you've had an opportunity to gather more information, and when citizens see it on the city council agenda, then they come and talk to you about it, because they don't come and talk to us a lot of times. So I just want to share that you had the benefit of a lot more information. And it's hard for us sometimes. We do the best we can, but we don't have a lot of information. We just got the data.
Ben, I think that you had mentioned in the last week, I apologize, I think you had mentioned in the last week that you guys were going to try to give them more information. Okay, that conversation had happened. Thank you.
Yes, the goal is when you're getting, it's kind of a weird term in city administration, gnarly topics that are not your usual normal routine business, is to make sure staff through the proper channels is communicating to you all a little bit more than just the standard packet of information, so you have a better, broader scope and understanding of the information you're considering. That way you're not blindsided. Nobody likes to be surprised, nobody likes to be blindsided. It also allows for a more constructive conversation with the residents, because when they do show up, you're like, oh, and then you see me sitting in the audience, why is the city manager sitting in the audience? Well, we knew this was going to be an interesting discussion. So when we know we're gonna have those kind of topics, we're gonna work with our team to make sure we're having a better interface and can get you hopefully more information for a more constructive conversation. So again, you all can feel like y'all are delivering, because you're gonna be just as frustrated, just like councils, if they don't have the information, right? You wanna be able to have that constructive conversation, and we wanna get off to the right foot with the residents as well. That way we, as you've heard council talk about as well, is getting ahead of misinformation or misunderstandings. Residents are passionate about this. Let's equip everybody to have a good, productive conversation and focus on the real issues that P and Z can influence and the council as well, not the non-issues that maybe there's just a misunderstanding. So we understand this was an opportunity and it was highlighted with the most recent item.
Anything further, commissioners?
I remember one for the city attorney. Did I hear you say that citizens have the right to do comments that are items that are on or off the agenda, and comments that in a public meeting? Is the way we do it currently is at the beginning of the meeting, you can only make a comment if it's not on the agenda. And I just thought, I wasn't sure if I heard that correctly, where you were
Well,
saying.
some cities distinguish between two different categories of citizens' comments as two separate items. One for citizens' comments for items on the agenda, and one for comments that are off the agenda. I had a city once that had citizens' comments at the beginning of each agenda item. This was the city council, not P and Z. And that meeting with 5, 6 items on the agenda lasted 3 to 4 hours, I was insane. The Open Meetings Act required, it gives the public the right to provide input on any matter before or during consideration. Virtually all cities, and P&Zs and BOAs as well, will allow citizens to comment on any item, whether it is on an agenda or not on an agenda. And so ideally, you'll have one broad agenda item and you'll let them speak for 3 minutes on whatever they want to talk about, even if it's just the weather. I mean, and I'm serious about it. Even if it has nothing to do with the P&Z's authority, give them their 3 minutes. Even if it's criticizing the P&Z, the council, or the city attorney, you give them their 3 minutes, right? If it is an item that's on the agenda, and it is not posted as a public hearing, their opportunity to spend 3 minutes to talk about that agenda item should have been done during the very beginning of the agenda, during the generic citizens' comment item, right? If it is scheduled as a public hearing, and they've already spoken during citizens' input, you don't want to give them 6 minutes, you want to give them 2 bites. You can if you want, but you don't have to give them 2 bites at the apple. So when they're speaking during the generic citizens' input, whether it's an item that is on or not on the agenda, once they start talking, and you can see that it's about something on the agenda item number 5, and just say, look, if you want to talk about this agenda item, you can do it now, or you can wait until the public hearing as you get down the road. Not a good idea to allow separate citizens' input before every single agenda item that is not identified as a public hearing. You understand? Because
Yeah,
it'll be-
yeah, exactly. It says, because currently it's very explicit. It says at the beginning of the comments are, if it is not on the agenda, if it's on the agenda, you're not allowed to speak. That's the way it's currently run.
Yeah, probably need to relax that a little bit.
Okay.
Yeah.
Thank you.
With no other comments on item D3, we will, I don't believe we need to take any action. So we will move to adjournment, and I will adjourn our Planning and Zoning Commission part of this joint meeting.
Thank you very much. There is no action taken as a result of executive session, so seeing no further comments from council, we will adjourn our portion of this meeting at 6:11. And thank you all very much for coming.